Welcome to this Tuesday discussion with Lena Köhn. Wonderful to have you here, Lena. My name is Christoph Mauch. I'm the director of the Rachel Carson Center, and it's a pleasure to have Lena here. She is working on the Derechos de la Naturaleza in Ecuador, on the rights of nature in Ecuador. Well, one thing I should say, after this session, which lasts until 5:30, we will also, those of you who are interested, talk a little bit about a project that we are part of called SPEAK4Nature, which is an EU project, and gives people at LMU the opportunity to go to other places around the world, from Argentina, Brazil. Jonte is going to Brazil, and Catherine is going to Madrid, and so it's a program about ecological justice and about the rights of nature. But Lena, you come from Berlin, but but really from Munich. You've lived in Munich for a long time, and it's not normal that you automatically. I mean, you wouldn't think of Munich as the place where you learn something about rights of nature. It's a very Latin American topic, and it would seem even less imaginable if you know that Lena attended a humanistisches Gymnasium. That's a grammar school of the old type, where you learn Latin and Greek, and so she got a Latinum and a Graecum, so degrees in Greek and Latin, but certainly not in Spanish. So what happened is that Lena, at one point in 10th grade, went to the German school in Santiago de Chile. Mm-hmm. And because Latin and Greek were not enough for her, she loves languages, she studied Spanish herself and became quite fluent, even during her school time. And then after Abitur, she was working in Nicaragua, in Granada? Or, yeah. Because I think that's where these projects are. The Proyecto Mosaico is an NGO that is in Berlin and in Granada, Nicaragua, and they have great projects for volunteers. They work on environmental education and water and topics like this. And so this explains why she's interested in nature, and explains why she speaks Spanish fluently. She said, I can speak Spanish fluently, just like German, but it's more difficult for her to speak English. She said, let's see. But it doesn't explain the rights part of, rights of nature, and that's obvious. She just said, I put my lawyer's blazer on today, but everybody knows I'm a lawyer. She studies law, is finishing her dissertation on the rights of nature in Ecuador, and she studied in Münster, which is really one of the greatest universities for law. But then she studies with the coolest law professor who's been on our board for a long time, Jens Kersten, who many of you know. So Jens was actually going to write a book about the rights of nature in Ecuador. I think he really wanted to do that. It was his favorite project. But then when he met Lena, he realized, here's somebody who can really do this better than me. And so this is why Lena is here with us. So please join me in welcoming Lena Köhn.
Yeah, thanks. And thanks, Christoph, for this very nice form of introducing me. First of all, I'm really sorry. I'm normally working in Spanish and in German, and now I have to translate everything that I found out to English. So if you have any troubles in understanding me, please just raise your hand. As Christoph said, I'm working on rights of nature in the Ecuadorian constitution, and today I'm gonna have a more general overview over the constitutional remedies that the Ecuadorian constitution gives to the people of Ecuador to defend nature before the Constitutional Court. And then we're also going to look into one concrete case, into the case which has been very prominent, you might have heard about it, the referendum against oil extraction in the fields ITT, Yasuni ITT in the national park, partly in the national park Yasuni. And from time to time during my presentation, we're going to also have a short look into the German constitution to ask ourselves, would this, what we're seeing in Ecuador, be possible in Germany? and can we maybe learn from Ecuador? So, how can you defend nature? How can you speak for nature, if you want to say so, in Ecuador? So, during my research, I realized that there are mainly 3 mechanisms that have proven to be very effective. So there's first the collective rights. You might be a little bit surprised by that. First, to ask, what is collective rights? So collective rights is rights of groups with a certain collective identity. So in Ecuador, that's like especially indigenous peoples. And they have some specific rights. For example, very prominent, the right to prior consultation. So before like an extractive project is carried out in their territories, they must be consulted. And that right, you might think, okay, like what does this have to do like with environmental protection? How can you enforce environmental protection through the right of prior consultation? But in fact, it has been proven very effective because the International Court of Human Rights has set a very, very high standard on this, like right to prior consultation. So it's necessary, for example, that the people must be very well informed before consenting and that the consent is in good faith. So for example, and that is just like never happening, never, that the company must not take the decision beforehand. They must go into this meeting with indigenous tribes like without being just open-minded, saying, okay, we're now going to discuss like whether we want to do this project or not. And obviously what is happening in Ecuador is that they just show up and they bring some, cake. They're like, this is the project that is happening, like, are you on board? Yes, very good. So, and with this like reality in mind, you can see why it's a very effective mechanism. In fact, like before the Inter-American Court of Human Rights, for example, in the case of Sarayaku, or before the Ecuadorian Constitutional Court, to actually like prevent those projects from happening because the standards are never fulfilled. And I mean, like, obviously, not all indigenous people always object to like extractive projects. That's like obvious, but there are some people who do, and especially in Ecuador, they're very well organized. So, secondly, rights of nature. That's my topic. So that's actually one of the most innovative parts of the Ecuadorian Constitution, Article 71, 72. So in Ecuador, not only humans have rights, as in Germany, but also nature itself, meaning like all parts of nature. And the 3 rights are the right to exist, the right to maintain and regenerate life cycles, evolutionary processes, and the right to restoration. So usually the right to exist is vulnerable because there's like a certain population put like seriously in danger or something like that, and then the right to restoration becomes relevant. And really like unthinkable out of a German perspective, those rights can be claimed by every citizen of Ecuador, like alone or collectively. So everyone who could just wake up with the idea of defending a river which you think that is polluted could just, file a case before the Constitutional Court of Ecuador. And then, lastly, another right that is quite different from the other ones, but has proven to be very effective in the last few years, is the right to referendum. So basically, the right of the people to make a binding decision instead of the legislator, basically on a topic of their choice. So there will be like a prior decision of the Constitutional Court of Ecuador examining whether the question is constitutional. So you can't decide on the question, can women still go out or not? That's an unconstitutional question. Or you have to phrase the question in a clear way. Otherwise, if the question is kind of difficult to understand, it would also be unconstitutional question on formal grounds. But obviously that's the right to, that right is like very, very powerful because it gives actually the people, as we will later see in the Referendum Yasuni, the right to stop ongoing oil exploitation or other extractivist projects just by voting. You don't need to file a case. You don't need to wait for the Constitutional Court for years. Maybe you get the decision on the constitutional question and afterwards you do the referendum, you vote, and you have your answer. The referendum is binding. Okay. So why am I telling you all this? Why is that interesting? Because none of those mechanisms exist in Germany. So obviously we don't have any indigenous rights because we don't have any indigenous groups. That's obvious. But we also don't have a comprehensive right to referendum on federal level. So there's like no chance to do referendum on questions of environmental protection in Germany. Basically, the only topic where you can do a referendum in Germany on federal level is if you want to restructure the German territory. So if you want to, change the borders, that's the only question. And there are obviously also no rights of nature. We only have human rights. And we don't even have a right to a healthy environment. So basically this connection between humans and environment is not recognized on the constitutional level in Germany. So the only constitutional mechanism, the only tool that we have in Germany is Article 20A. You might have heard about it. There was quite a prominent decision 2 years ago of the German Constitutional Court. But in fact, it's quite a weak provision. So it says, mindful also of its responsibility towards future generations, the state shall protect the natural foundations of life and animals by legislation and in accordance with law and justice by executive and judicial actions, all within the framework of the constitutional order. And two main problems that we're dealing with when we have to apply this provision is first, it's only application for the state, but it doesn't give like any subjective right to the individual. So no rights of nature, no human rights, which then means on a procedural level that you can't claim a violation of Article 20A before the Constitutional Court. And as always, if you can't claim a violation of a right, it's a very weak provision, because it can't be enforced by the courts. And then it's also quite abstract. You might not notice it, but it's a so-called Staatszielbestimmung. That means that it is like depending on the concretization of the legislator or by the legislator. So the legislator actually has to determine what is the environmental protection standard that we want to reach. And if he doesn't like regulate anything, then we might have a problem. But it's not unconstitutional. So obviously, you can see the German constitution is, in comparison to Ecuador, very reluctant to make environmental or even climate protection enforceable before the Constitutional Court. So the question that arises is, can we maybe learn something from Ecuador? Okay, and maybe the question that has popped up in your head is, okay, all nice, but the Ecuadorian constitution has 444 articles. I'm sure that not every right is enforced. And this is only law in books. What about law in action? Are those rights really applied? Are they enforced? And during my research, I especially was observing a trend towards enforcing environmental protection from 2018 on through constitutional judgments and anti-extractivist referenda. Why is that so? So I conducted 20 interviews and read a lot of texts, read a lot of judgments, and the conclusions that I've come to are that there are several important factors. So first, in 2018, the President Lenin Moreno, he started a process of restructuration of the Constitutional Court itself. So especially he to make it more independent, and he restituted all the judges that were elected during the term of office of Rafael Correa. And Rafael Correa is said to be to have been very strongly involved within judicial decisions. So he was a very strong president, and he had that is what basically every interview partner told me, have very strong links also into the judiciary to tell them what to decide and what not to decide. One quote, for example, by Rafael Correa is, "There's no decision against the interests of the state." So, yeah. So that is one factor for sure. And then, I think even more important, that the judges that were then elected in 2019, there were 3 of them that had previously worked with human rights, especially with indigenous people's rights and with rights of nature. For example, Ramiro Avila, Agustin Grijalva, and Daniela Salazar. Especially Ramiro Avila, he was already present in the process of designing the new constitution and was a strong advocate for rights of nature. And he then became constitutional judge. And what also different interview partners told me, and I think it's quite plausible, is that, and you can also see that there have been really a bunch of cases that with the first favorable decisions of the Constitutional Court, for example, the case of Los Cedros, in favor of nature, that the plaintiffs began to realize that defending nature is no longer hopeless. So it's not a caso perdido. Because obviously you spend time, you spend money on those cases. If you're defending a tree, you won't get paid for it. So if you are as idealistic to do that, you must at least have a chance to be winning the case. And they noticed from 2018 on, that's what they told me, that there was a chance of winning, and then this really produced this flood of cases that were filed before the Constitutional Court. And with particular view to the referenda, there was actually an important change of precedent, which made the referendum more accessible to the public in 2019. So because of a decision of the Constitutional Court in 2019, it was no longer necessary to reach the necessary quorum of 5 to 10%, depending on the referendum, before going to the Constitutional Court and asking them to examine the constitutionality of the question. Why is that important? Obviously because it's really a difficult task to get 5 to 10% of the people just living in the region to sign your petition. And if you have done that for 1, for 2, for 3 years, you don't want to file a case before the Constitutional Court asking them to examine the constitutionality of the question that you have, presented to the people, and they're no, sorry, unconstitutional, which had happened several times. So that's now made way more accessible when the Constitutional Court said, okay, first we check the constitutionality of the question, and then you start to collect the signs to reach the quorum, and then the Electoral Council sets the date for the actual referendum, and you can vote yes or no. And let me now give you one particular example, if you're still interested, and to tell you about one recent case where this right to referendum recently has become very important, very relevant for, first of all, the protection of the indigenous tribes, but secondly also for environmental protection in the National Park of Yasuni. So, as you mostly know, for sure, the National Park Yasuni is Ecuador's largest national park. It's a highly biodiverse area, and it's also home to the only 2 indigenous peoples in voluntary isolation, Tagaeri and Taromenana. And because of those particularities of the park, Alberto Acosta, that you might also know, suggested in 2007, I think, I don't have that on the slides, that they should not extract the oil in the parks, particularly in the fields ITT. Rafael Correa said, yeah, all fine, but under one condition. We don't extract the oil, but only if the international community pays us half of the money that we're losing if we don't extract the oil. That was the idea. The initiative Yasuni ITT, very prominent. Because obviously we are contributing to protect a highly biodiverse area. This has also positive impact on climate, so we must be recompensated. this initiative fails because they don't gather enough money. So the international community can't pay enough money or is not willing to pay enough money. So Rafael Correa said, okay, plan B. Who said plan A is not extracting if we get the money? Now plan B. Plan B is oil extraction. That begins in the year 2017. And also before, there had been like numerous public protests. The movement Yasunidos was formed, and they tried like really several times throughout 10 years to hold a referendum to stop this oil extraction. And that was basically hindered by the Electoral Council and also the Electoral Tribunal, because the Electoral Council just declared the votes invalid. So they said you don't have the quorum to do the referendum because you didn't gather enough votes, and the Electoral Tribunal didn't do anything. Then the Constitutional Court, and only like after the Constitutional Court decided that they had to restitute the judges of the Electoral Tribunal, only like after this decision of the Constitutional Court, they said, okay, we were wrong. You have the quorum. Your votes were not invalid. But I mean, like that maybe tells you something about like how independent some courts are, but also tells you something about like the Constitutional Court of Ecuador, which like at the time is known to be very independent, and like there also in 2018, I think, told the Electoral Tribunal, okay, like this decision is not plausible at all. We don't see why those votes are invalid. I think you're corrupt. And the judges had to be restituted by new ones. And after this decision, they decided, okay, you have the necessary quorum. And then after 10 years, literally, of societal engagement for the preservation of Yasuni National Park, the Constitutional Court ruled on the 9th of May, like of this year, basically, that the question put to referendum, which is, do you agree that the Ecuadorian government keeps the oil from ITT indefinitely underground, so it doesn't extract the oil, is constitutional? And what were their arguments? So their main argument was, which is basically surprising to lawyers, that the right to legal security is not violated. Because, I mean, the oil extraction, as I told you, was already going on. Like Petroecuador, which is the company, had the necessary concessions, they had the necessary environmental permits, they had already like filed the contracts with also staff and bought the goods and stuff like that. And still they said, and they had pre-sold like a big part of the oil. So even if they hadn't extracted it so far, that they already pre-sold it. And like keeping in mind those facts is quite surprising that the court still said, okay, the right to legal security of Petroecuador is not violated, mainly because of two arguments. First, they said, I mean, like, you have been fighting for this referendum now, Yasuni is for 10 years, like it's basically foreseeable that at some point you might succeed. And the second point is that you can fulfill your contracts of pre-sale also like with the oil from other fields that you're extracting from other fields. So the right to legal security is not violated, but still the court said, okay, but in case of yes, if of a referendum which decides to stop the oil extraction, there will be a transition period of 1 year to allow you to stop the extraction literally step by step. Yes. So, after this positive decision of the Constitutional Court, the popular referendum Yasuni took place this August, and the result was yes. So they decided basically 58% of the people that voted nationally, it was a national referendum, decided that they wanted to keep the oil underground, not to extract anymore in the fields Yasuni ITT. And Petroecuador, I think one important factor is that Petroecuador is actually a state-owned company. So they can't say, okay, guys, so you have done this referendum under 104 of the Ecuadorian constitution, but we don't care. Like, that's difficult for a state company. And I think in this case, they were lucky that it was not like a Chinese company. So they accepted the referendum and decided, or not decided, told that they are willing to stop the extraction on the 31st of August of 2024. With like really great financial consequences. So only the dismantling of the installations is estimated to cost like $1.8 billion, and the daily production estimated to be like 45,000 barrels in 2022 resulted in a revenue of like approximately $1.1 billion, which like in Ecuador is basically only in those 3 fields, like not in general. Only in those 3 fields is like 1% of the GDP, which is like literally a lot. So when I told this to my boyfriend, who's a geographer, he told me like it's literally so surprising, and I think he's absolutely right, that almost 60%, like in a national referendum in Ecuador, vote to stop the oil extraction, whereas like the most prominent argument worldwide, one of the most prominent arguments against environmental protection, against like climate change mitigation, is that like economic strength and maintaining prosperity is like the necessary precondition to take action. So thanks a lot for your attention, and I'm looking forward to our discussion. We might ask ourselves, can we learn something from Ecuador? Do we also need more direct democratic elements to speak for nature? Or are rights of nature or right to a healthy environment a suitable amendment to the German constitution? Thanks.